Good day, everyone. Welcome to the official LSA YouTube channel. This session would be for law of contract and it would be placed in different parts, so it's safe to say this is part 1. This would be a summary of law of contract that would help you during your studies, just for a better understanding of what contract law is all about. Welcome to law of contract. Let's begin. What is a contract? Contract is based on a promise theory. The idea is a contract involves two parties. You promise to wash my dishes and I promise to pay you afterwards. A contract can be said to be an exchange of promises where the promises are enforceable by court. Although not all promises are enforceable. If your friend promises food, when they get back, you cannot enforce it if they do not get you the food. A contract is defined as an agreement which the law will enforce or recognize as the legal rights and duties of the parties. So a contract can also be defined as a promise or a set of promises the law will enforce. Thus, as we shall see, not all agreements will be enforced by law. For example, social and domestic agreements are generally not binding in law. Also, the court will not, except in special cases, enforce an agreement unless it is supported by consideration. In Oyewale versus Lawal, Fabi JCA, as he then was, adopted the following definition of contract from pages 291 to 292 of the 5th edition of Black's Dictionary. He says it's an agreement between two or more persons which creates an obligation to do or not to do a particular thing. Also in Cabo Air versus Tarfa, Galadima JCA, as he then was, held that a contract must be an agreement which is legally binding on the parties to it and which, if broken, may be enforced by action in court against the defaulting party. Now, let's talk about contract formation. So we have capacity to contract, intention to create legal relations, offer and acceptance, consideration, and also certainty. Let's look at these in the next slide. Let's talk about capacity. Now, the general law is that everybody is assumed to have the capacity to enter a contract. However, there are exceptions. The first one, mental incapacity. It is obvious that people with mental incapacity do not have the capacity to enter a contract. Therefore, it could be enforced by them, but not against them. This makes the contract voidable. A contract would be voidable if the other party knew or should have known of the incapacity. Please see Gibbons versus Wright. Secondly, minors. For people below the age of 18, the general rule is that contract made by a child is voidable. This means that it could be enforced by the child, but it cannot be enforced against the child. So a child could sue you if you don't fulfill a contract, but you can't sue a child if he fails to do his or her own part. The law is if you make a contract with a child, you do it at your own risk. The reason for this is that a child lacks maturity, so oftentimes they may not be able to consider the nature of the obligation they're actually taking on. There are a few situations where a contract can be enforceable against the child, and these are contracts for necessaries. Please see Peter versus Fleming. Necessaries are things that young persons would ordinarily need. You can't enforce a contract for necessaries if the child already has supplies of those necessaries. Please see Nash versus Inman. Contracts can also be enforceable against children by beneficial contract of employment or education. Check Green versus Thompson. Another exception is intoxication. A similar rule is in place when a person is so intoxicated by drugs or alcohol that they do not understand the obligation or nature of the contract. This makes the contract voidable. Please see Matthews versus Baxter. So if a person that does not have capacity makes a contract and later obtains capacity to enter into the contract, they may choose to either repudiate the contract, this means to pull out of it, or they may ratify the contract, which means they agree to the contract and now they have capacity. For example, a child may have made a contract when he or she was a minor. When the child becomes of age, they have the capacity to make a contract. They may choose to repudiate the contract they made when they were minor or ratify the contract. Now let's move into intention to create legal relation. This means they intend for it to be a contract that will be enforceable by law. The law makes two presumptions. First, that the agreement between families called social agreements between family and friends are not enforceable by court. The second presumption is a commercial agreement, an agreement which happens in a commercial or trading context between people who are not family and they are intended to be forcible. See Edwards versus Skyways. It must be noted that these presumptions can be rebutted. That means family members can make business arrangements among themselves. Also, commercial agreements can be in honor only, which means that the contract is not enforceable. Offer and acceptance. An offer can be said to be a set of proposed obligations the offerer is willing to be bound by. See the case of Kylo versus Kabbalic Smokeball. An offer may be made to one specific person or to the whole world at large. There are a few things that look like offers but are actually not offers. For example, an advertisement. It may look like an offer, but they are actually invitations to treat. See the case of Partridge versus Crittenden. In other words, an advertisement invites you to make an offer, but it is not an offer. Also, goods on display are not offers but invitation to treat. So if you go into a store and you see goods on display with price tags, it doesn't mean they're offers. See the case of Fisher versus Bell. You make the offer when you take the goods to the cashier and the store accepts your offer. In case of machines, ticket machines and vending machines, the machine makes the offer and you accept the offer when you put your money in it. In auctions, the offer is made by the person making the bid and the offer is accepted when the hammer falls or when the auction period ends. Each bid is an offer. This was held in the case of Smythe versus Thomas. Once an offer is made, a number of things may happen. The party receiving may make a counter offer. A counter offer extinguishes the previous offer. An offer may also be withdrawn. To withdraw an offer, the person who made the offer has to communicate to the other party that he or she wishes to withdraw the offer before acceptance. Note that once it is accepted, the offerer cannot withdraw. It can also be withdrawn if there is a time limit for acceptance and that time runs out. The offer is also withdrawn if the person who made the offer dies. If the person receiving the offer agrees with it, then the parties are ad idem. That is Latin for one mind, which also means absolute agreement. Acceptance becomes valid when communicated to the offerer. Silence, thus, does not constitute acceptance. Parties can also choose how the offer is to be accepted. The most obvious way would be by signature, as established in Lestrange versus Greco. Contract accepted by signature would be binding. Another way a contract will be accepted is by conduct, that is, carrying out your obligation in a way that shows acceptance of the agreement. Acceptance by post. Unlike the other modes of acceptance earlier referred to, the rule with regard to acceptance by post is that acceptance takes effect and therefore the contract comes into existence the moment a letter of acceptance is posted. This radical departure from what is normally regarded as the moment of acceptance has been justified on various grounds, which we shall consider later on. This rule was first laid down by Lord Ellenborough in 1818 in the famous case of Adams versus Lindsay. In the United States, recent decisions suggest a move away from the rule in Adams versus Lindsay as a result of postal regulations which now permit writers to recover posted letters before they are even delivered. It has been held that acceptance is no longer complete on posting. There are, however, exceptions to the rule of Adams versus Lindsay, which are 1. Where the terms of the offer either expressly or implicitly indicate that acceptance must reach the offerer. This was suggested in Household Fire Insurance Co. versus Grant. The rule in Adams versus Lindsay can be displaced by any offerer who indicates that acceptance is to take effect from only the time of delivery of the letter of acceptance to him. 2. Where the application of the rule would produce or manifest inconvenience and absurdity. 3. The rule does not apply where the letter of acceptance is wrongly addressed or inadequately stamped. And finally, it does not apply where the letter was not properly posted. Note that acceptance has to be made with knowledge of the offer. You must actually know of the offer in order to accept it. Let's talk about consideration. In this sense, this may be described as what you give to obtain a benefit of a contract. Money and goods may be consideration, but as well as conduct. This was seen in Kylo versus Kabbalic Smokeball. Cool. Promise may also be a consideration. See the case of Cutter versus Power for more light on that. Forbearance can also be a consideration. Please see the case of Hercules Motors versus Schubert. The general rule is consideration must be sufficient, which means it must be valuable, but it need not be adequate. This means that consideration has to have some type of value. However, it doesn't need to be on equal value on the contract. The rule in Pinel's case. Payment of a lesser amount cannot be good consideration to discharge a debt. Thus, if A owes B $5,000 and agrees to pay at a certain date, the payment of $3,000 does not discharge the debt. B would be able to sue no matter the agreement made. However, there are exceptions. If the payment terms change in favor of the creditor, that means paying earlier when the person needs money urgently, for example. Certainty. A contract is uncertain when the words are too vague that the court cannot even understand. Sometimes uncertainty can be resolved by looking to an external standard, and sometimes severing the uncertain words will resolve the problem. Thank you for making it this far into the video. We do hope this summary helped you. Please stay tuned for part 2 and don't forget to like, comment and subscribe, and please turn on your post notifications so you get notified every time we make an upload. Do have a lovely day and bye.